Disclaimer. This podcast contains sensitive material which includes murder and violence. It will not be suitable for all listeners. For a list of confidential support, please see our show notes for more details or visit our website. Listeners' discretion is advised. On the 10th of January 1989, Canberra's residential suburb of Deakin was particularly quiet. It was the summer holidays, and the outside air was warm and still. It was 8 p.m, but not yet dark. Inside many of the houses, people gathered around their TVs, excited at the anticipation of the close day-night cricket match between Australia and Pakistan. Disinterested in the match, Colin Winchester drove from Deakin to his brother Ken's house in Queanbeyan. Winchester had knocked off work a few hours earlier and decided to see Ken to discuss their next day's pig shooting expedition to Burke in New South Wales. Happy with their plans, they tinkered with their guns and ammunition before Winchester, exhausted from work and ready to get some sleep, called it a night and headed off on his short 14-kilometre drive home to Deakin. When Winchester arrived home, he drove up his widowed neighbour's concrete driveway in Lawley Street, as he always did, stopping his car beside her cladded red brick house. He parked his car in this spot, as his neighbour had told him she drew comfort, knowing there was a car parked near the entrance to her house. Winchester shifted the gears into park, applied the handbrake, and turned to the passenger seat. He picked up the pack of ammunition for the next day's journey, turned off the lights, and began to step out of his Ford Falcon. Then he was shot by a gunman standing behind the car. The first bullet hit Winchester in the back of the head behind his right ear, causing his collapse back into the car. Within seconds, the gunman stepped over and fired another shot, directly into Winchester's right temple. From inside their home, his wife Gwen heard noises like sharp stones coming up onto the front of the window, as if children were throwing stones. And then she heard the piercing sound of a car screaming down the road, driving frantically away. Gwen had known that Winchester had arrived home. She saw him pull into the driveway and thought her husband was playing some type of prank on her, as he had not come into the house. When 5 minutes had passed and he still had not climbed the stairs to their front door, she walked outside to find him. The Ford sedan's interior light was on, and she could see her husband sitting in the driver's seat. As she walked around to the right side of the car, she found Winchester slumped behind the steering wheel, his right leg hanging out of the open car door. Panicked, Gwen shook him, but he didn't move. Unsure of what had happened, and thinking he might have had a heart attack, Gwen rushed back inside the house and called an ambulance. Colin Stanley Winchester was, at the time of his death, the highest-ranking police officer serving in the Australian Capital Territory, also known as the ACT. He was the Assistant Commissioner of the Australian Federal Police. Prior to joining the police force in 1962, Winchester worked as a miner near Captain's Flat in rural New South Wales. At the age of 29, he joined the ACT police force and then spent almost 3 decades as a police officer. In 1979, Winchester was appointed Chief of the Criminal Investigation Branch, at the time when the ACT Police and the Commonwealth Police were merged to form the Australian Federal Police, also known as the AFP. The Criminal Investigation Division was known to be a tight-knit group which dealt with national crimes against Commonwealth laws, such as tax fraud, guarded Commonwealth buildings, and handled the criminal investigation units of Customs. The merging of the two forces was not popular with the local ACT police, who referred to the Commonwealth Police as plastics. This was due to their alleged lack of actual police work on the ground, which saw the former ACT police criticising the others' alleged continual incompetence, mismanagement and mistakes. In 1984, Winchester was appointed the Assistant Commissioner of the Australian Federal Police. Some people remarked on his impeccable manner and described how he took his role very seriously. However, his manner was questioned when Winchester was approached by a Calabrian man who offered him $20,000 to turn a blind eye to a planned cannabis crop near Bungadore, which is not far from Canberra. Winchester accepted the offer. After calling the ambulance, Gwen returned to the car and hysterically grabbed her husband. She attempted to resuscitate him, and then noticed her hands were covered in his blood. She saw the packet of bullets in his lap and threw them away. For a moment she thought he had committed suicide. After the attempted resuscitation, Gwen made a second call to 000, calling for police to attend, because she realised her husband was already dead. The police officers arrived and frantically searched the immediate area, where they found 2 PMC cartridge cases, but no weapon. The crime scene was a mess. Some of Winchester's colleagues arrived on the scene, deeply upset by what had occurred. No one was able to take charge, and those trying to preserve the scene by trying to clear the area were told to piss off. The murder was an offence against the ACT law, and therefore sat within the jurisdiction of the ACT branch of the Australian Federal Police. There were 2 task forces established by the Senior Commissioner. The first was to investigate any evidence suggesting that the murder was the work of organised crime, and the second, staffed by ACT detectives, was to look at motive and suspects. Within 1 hour of the murder, investigators began to zero in on the movements of a former detective who had left the ACT force on bad terms. He was soon located, but to the investigators' dismay, he presented an excellent alibi. Examination of the 2 cartridge cases at the scene by Superintendent Pryor led investigators to believe that the murder weapon was a Ruger 10-22 rifle fitted with a silencer, which accounted for the muffled cracks Gwen had heard. Many detectives believed the second shot to be the double tap, a clear sign of a professional assassin. eyes began to turn to the idea that this may have been the work of an organised crime syndicate, particularly 'Ndrangheta, a Calabrian mafia organisation dating back to the 18th century. The National Inquiry soon gathered intelligence of unusual activity with 'Ndrangheta, showing reports of hitmen departing from Italy, and receiving advice from Italian police that there was an array of intercepted calls in the Calabrian dialect, referring to a traitor getting the bullet. However, some of the evidence came from informants with access to powerful crime figures, and therefore the prosecution was able to secure Crown privilege over their reports, which meant the public could never be told what was in them. The thing was, Winchester had only pretended to take an interest in the money. He had actually placed it in a police safe and recorded each conversation with the would-be bribers. While Winchester was the liaison point between his contact and other senior players in the 'Ndrangheta, he was anything but corrupt. Because he shared all this information with the New South Wales police, the 'Ndrangheta were unsurprisingly angry when they found out. Their trial was due to start in Queanbeyan Court in February. Winchester had been subpoenaed by the Defence Counsel, in the hope that it would be suggested that Winchester had been leading the organised syndicate into illegal entrapment. As a matter of urgency, a forensic scientist was called to examine the murder crime scene, arriving a few hours later at 3 a.m. on the 11th of January 1989. Robert Barnes was from the Victorian Forensic Science Laboratory. His area of expertise was in the collection and interpretation of gunshot residue. Upon arrival, Barnes undertook an extensive examination of the scene, collecting samples from both gunshot entry wounds and from selected areas of the car. A few hours after Barnes had conducted his initial forensic investigation, Sergeant Nalippa vacuumed the ground in the immediate area of the driver's door of the car. Winchester's car was then impounded and searched for gunshot residue on the 18th of January 1989 by both Nalippa and Barnes. The gunshot residue was analysed before and after firing for particular compounds and shape, colour and behaviour upon firing. Of the 151.22 ammunition types available in Australia, PMC was considered to have the unique factor when all of them were considered. Police appealed on television for more information about Ruger rifles. Shortly after the request for information appeared on TV, one Raymond Webb contacted the police and told them he had seen one at a Mr. Clarenbeek's house. David Harold Eastman was another early suspect in the shooting, as he had had direct contact with Winchester in the weeks prior to the murder over a perceived mistreatment. Investigation into Eastman showed that he did not fit the mould of a common criminal defendant. Eastman was born on September 29, 1945, and had attended Canberra Grammar College, graduating as dux of his year. He was often described as being highly intelligent, emotional, and arrogant. In the mid-1960s, he secured work in the Australian Public Service. 17 years later, Eastman left his job in the Treasury Division and engaged in unpleasant disputes over the wording used upon his departure, ultimately deciding to return to work. In August 1987, two public service officers claimed that Eastman made threats of violence against them in their roles at the Department of Finance after a rejection of his compensation claim. In December, just 5 months later, he was charged with assault, and thus began his long battle to clear his name. Eastman's first assault charge arose out of an incident with his neighbour, Mr. Russo, over a garage, where the argument included punches being thrown. Eastman felt the attending police had been unfair by charging him over the incident, and that the police were corrupt, as, in his view, Mr. Russo had been the aggressor. Unfortunately, the assault charge posed a serious obstacle to his re-entry to work in the Commonwealth Public Service, and Eastman was enraged about this. At one point he remarked, "I'll probably have to kill someone to get attention paid to the injustice that's been done to me." Eastman sought out the AFP to assist him in having the assault charges dropped, believing he should never have been charged. Unfortunately, he was hampered by poor mental health. He engaged Neil Brown QC in his efforts to clear his record and obtain re-employment in the public service. He requested that Brown arrange an appointment with Winchester, stating that he wanted the charges dropped and the police matter cleared up. After some discussion, Brown was successful in obtaining an appointment to attend with Eastman to meet Winchester. The meeting was held on the 16th of December 1988. However, much to Eastman's disappointment, Winchester refused to intervene. Winchester observed that it was a matter concerning the Director of Public Prosecutions, and that it would be resolved by a magistrate. This response completely exasperated Eastman, who said to Winchester, "If your hoons think they can treat me like this, they've got another think coming." Winchester defended the police, but said he would write to Brown QC with his final answer. Brown received the letter stating that Winchester would not intervene on 20 December 1988 and forwarded a copy to Eastman. 1 month later, during a visit to his doctor, Dennis Rowantree, Eastman discussed his anger. After mentioning that he was worried about a pending assault charge, Eastman said, referring to Winchester, "I should shoot the bastard." At 9:30 a.m. on the 10th of January 1989, Australia Post delivered Brown's QC's copied letter, stating that Winchester would not intervene with the assault charges, and that his charge had been listed for hearing on the 12th of January 1989 to Eastman's residence. That same night, Colin Winchester was shot dead. The following day, the 11th of January, Eastman was interviewed by Detectives Thompson and Jackson. They questioned him about his meeting with Winchester on the 16th of December 1988 and asked his whereabouts on the previous night. Eastman stated that he had been driving around Canberra but could not recall the times or locations. He suggested that he may have gone out about 8 p.m. and returned around 10 p.m. This was a regular occurrence for Eastman, who was quite lonely and spent each night going out on a drive to buy takeaway food, either a hamburger or a bucket of chips and a milkshake, whenever he felt hungry. His response made the police suspicious, and they made a quick decision to put listening devices in Eastman's home. When the media became aware that Eastman was suspected of the murder, the public and media flocked to watch every single step. An inquest into Winchester's death commenced in May 1989 and concluded in December 1991. The inquest was later reopened in November 1992 to take additional evidence. In December, 1 month later, the coroner committed Eastman for trial. On the 29th of March 1993, an indictment was filed in the Supreme Court of the Australian Capital Territory, charging Eastman with murdering Colin Winchester. On the 2nd of May 1995, before Carruthers AJ, Eastman was advised of the charges against him and pleaded not guilty. The trial began on the 16th of May 1995 when a jury was chosen. The prosecution's case against Eastman appeared strong and extremely well constructed. Prior to trial, one medical report described Eastman as unusually intelligent, persistent, aggressive, and abnormally suspicious. The Crown presented over 200 witnesses, almost 7,000 pages of transcript, and more than 300 documents and other exhibits. The prosecution told a story of Eastman's threatening conduct prior to the killing, linked him to the murder weapon and to the crime scene, and then painted a picture of his guilty post-offence conduct. The prosecution argued that Eastman's behaviour, comments and statements to the police about driving around Canberra demonstrated his consciousness of guilt. It was also submitted to the jury that Eastman was highly intelligent and was claiming memory loss so as to not portray his guilt, as it did not make sense that he would have forgotten his whereabouts on the 10th of January, knowing only that he was driving around Canberra. The evidence presented from the listening devices installed in Eastman's home were not clearly audible, so both the prosecution and defence each called their own technical voice experts. Several passages in the recordings were incriminating, and even the defence experts accepted that Eastman had probably said, "He was the first man I ever killed." However, the transcripts relied upon by the Crown offered varying versions, arguably to be significant admissions of guilt. When asked about the quality of the recordings, Dr. Andrew Butcher, Professor of Communication Disorders and the head of the Department of Speech Pathology at Flinders University in South Australia, stated, "I've been transcribing tapes for over 25 years, and I cannot remember recordings of worse quality that I've had to deal with." For example, one of the transcripts made by police officers McQuillan and Lawson read, "You drove more slow. I cannot miss him. You drove more slowly to give me a better chance. In fact, the situation was that I ran out of sight. It's pathetic. And then even when you called the first night and I've missed you, that was a very frustrating night. And I had to go back again the next night to kill him, the poor bugger. Then all of a sudden, you're dead. That keeps hold on me. So you go back the following night in the same car, the same registration number, the same driver, and your film crew's the same, and tried to set it up again. Finally, on the second night, you succeed. Honest, it's like trying to shoot miracles. Miracle, I haven't lost it. It required about 50 takes before you finally got what you wanted. I mean about the only thing you didn't do. You didn't provide me with a bag full of stones. Killed him. However, the transcript of the same passage, but transcribed by Dr. Butcher, was different. It read, "But you'd give me a better chance. In fact, the situation was that, out of sight, pathetic. And then even when you called and set it up, that was a very frustrating time. And I had to come back on the following night to kill the poor bugger. And I was waiting for to come. Fucking... So you go back the following night, the same car, the same registration number, the same driver, and you use the same and try to set it up again. Finally, as prophesied, you succeed. I know this is like trying to shoot the required about bang takes before you finally got what you wanted. I mean about the only thing you didn't provide me with was a bag full of stones." At this stage, the Crown's case had developed into a well-sewn story. By 1988, Eastman's attempt to regain employment in the public service had progressed, pending his assault charge. That charge had rendered Eastman at the mercy of the police, whom he believed to be corrupt. The sense of frustration that arose out of Eastman's ongoing battle to clear his name reached breaking point when he was denied assistance from Assistant Commissioner Winchester, and therefore he focused his murderous intent on Winchester. Inspection of the cartridge shells at the scene indicated that the weapon was a Ruger .22 caliber semi-automatic rifle. The weapon was not found. However, the shells were matched with shells from a Ruger rifle that belonged to Louis Clarenbeek. Clarenbeek had sold the rifle privately on the 31st of December 1988, but he was unable to identify Eastman as the buyer. However, another customer, Raymond Webb, who had contacted the police after seeing the appeal on television, had been at the seller's place around that time, and he identified Eastman as the buyer of the Ruger rifle. During the trial, evidence was also presented that Eastman tried to sell a sports store owner a Ruger matching the description of Clarenbeek's rifle on the 31st of December 1988. 2 days before Winchester was shot. While Eastman denied the accusations, he did admit that due to his fear of his neighbour Mr. Russo, who possessed a firearm, Eastman, in the 12 months prior to the shooting, had made numerous inquiries about rifles for sale, had bought and disposed of 2 rifles, and had considered buying another in November 1988. At no time did Eastman deny the accuracy of his telephone records presented by the prosecution. Those records matched outgoing calls to telephone numbers listed in advertisements for the sale of guns. The prosecution further argued that while Winchester's address was not listed in the phone book, in 1988 Eastman had inspected the electoral roll, from which Winchester's address could have been obtained. During the trial, Eastman raised constant and consistent complaints about police harassment, which contributed to the prosecution's attack on him. Eastman perceived the conduct of the police to be a form of personal victimisation, where they showed a bullying mentality and a pronounced aversion to any form of accountability. However, Eastman did not help himself, as he used crude language while in court, addressing the judge and when cross-examining witnesses. Adding to the circumstantial evidence, prior to the shooting, a car matching the description of Eastman's and with a close match to his number plate was seen outside Winchester's house. Forensic evidence found at the scene was detailed by forensic expert Robert Barnes, who stated that in Eastman's car he had found gunshot residue with a profile matching the gunshot residue found at the crime scene. On the 3rd of November 1995, after a long and difficult 85-day trial at which he represented himself, David Eastman was convicted in the Supreme Court of the Australian Capital Territory of the murder of Colin Stanley Winchester. He was sentenced to life imprisonment. As time passed, Eastman made numerous attempts to appeal his conviction. On the 25th of June 1997, in an unsuccessful appeal against his conviction, the Federal Court of Australia stated, "The Crown case established a very strong circumstantial case against the appellant. The force of the coincidence of so many strands of evidence combined to point the finger of guilt at him." An application for special leave to appeal to the High Court was granted. But on the 25th of May 2000, Eastman's appeal was dismissed. Then on the 9th of June 2000, he applied for a judicial inquiry into his conviction, pursuant to Section 475 of the Crimes Act of 1900. But on the 26th of July 2000, Eastman received a letter from the Registrar of the Supreme Court, notifying him that the Chief Justice had made an administrative decision not to grant an inquiry, and that the application was rejected. In his appeals, Eastman argued that the prosecution was aware that he had been unfit to stand trial because of his poor mental health, and that he was therefore entitled to a retrial. On the 31st of May 2001, Eastman again filed an application for an inquiry into his conviction. This time, the application was successful. The inquiry became known as the Miles Inquiry because it was ordered by Judge Miles. It examined Eastman's fitness to plead during his trial on the basis of his mental health. Between 2001 and 2004, Eastman made numerous attempts to have the scope of the inquiry widened to include the evidence led at his trial. However, those attempts were unsuccessful, and the scope was not broadened. On the 6th of October 2005, at the conclusion of the inquiry, ACT Chief Justice Geoffrey Miles published a report concluding that Eastman was fit to stand trial and that no miscarriage of justice had occurred. Less than a month later, Eastman applied to have that decision reviewed, but his application was rejected. On the 5th of October 2007, Eastman attempted to reopen the original appeal against his conviction. However, that application was dismissed by the Federal Court on the 18th of April 2008. Eastman filed several more applications for another inquiry. On the 29th of April 2011, he applied for an inquiry into his conviction pursuant to Part 20 of the Crimes Act. On the 3rd of September 2012, Judge Marshall granted the application, and an inquiry was launched into the conviction of Eastman for the murder of Winchester under Section 428 of the Crimes Act. The inquiry commenced before Acting Judge Duggan. However, in July 2013, for reasons associated with a conflict of interest, Justice Duggan withdrew from the inquiry. On 23 July 2013, it recommenced before a different judge, Judge Brian Martin. The scope of this inquiry was much more extensive and examined several issues around Eastman's mental health, the conduct of the police and prosecutors, and the forensic evidence. Oral and written evidence was presented, commencing on the 11th of November 2013 and concluding on the 12th of April 2014. Written submissions were made by the Australian Federal Police, Eastman himself, forensic analyst Robert Barnes, and the Director of Public Prosecutions. 6 months of hearings, more than 50 witnesses and 260 exhibits culminated in a 450-page report released 18 months after the inquiry ended, plus a confidential section that was not released to the public. The inquiry cost the ACT government approximately $12 million. The outcome was that Judge Brian Martin recommended Eastman be formally pardoned, stating, "While I am fairly certain the applicant is guilty of the murder of the deceased, a nagging doubt remains. The case against the applicant, based on the admissible and properly tested evidence, is not overwhelming. It is properly described as a strong circumstantial case. There is also material pointing to an alternative hypothesis consistent with innocence, the strength of which is unknown. In my view, the passing of so many years, coupled with the death of numerous witnesses, and publicity prejudicial to the applicant, mean that a further trial would be unfair to both the prosecution and to the applicant. A retrial would not be in the best interests of the community." On the 22nd of August 2014, the full court of the ACT Supreme Court quashed Eastman's conviction. Contrary to the recommendations made by Judge Martin that a retrial is neither feasible nor fair, a retrial was ordered by the Supreme Court. Later that evening, Eastman was granted bail after serving 19 years in prison. To escape photographers, he lay under a blanket in the back seat of a station wagon. Eastman made an application to permanently stop a retrial, arguing that there had been a considerable amount of adverse publicity about his alleged role in Winchester's death, and that the new trial was unwarranted. For reasons not released to the public, his application was unsuccessful. Eastman's lawyers then confirmed he had waived his choice for a judge-only trial, meaning the case would be heard by a jury for the second time. In 2016, prior to the retrial, it was estimated that the legal proceedings in the Eastman case had cost the ACT government in excess of $30 million. The government was forced to allocate special funding to it to preserve the budget for legal aid funding for other cases. In 2017, the ACT government set aside $7.4 million for the retrial. That amount was needed for funding the ACT courts and tribunal, legal aid, the Director of Public Prosecutions, and the ACT Police. Acting Judge Kelman presided over the retrial, which commenced on the 4th of June 2018. The 6-month retrial occupied 58 days of evidence, 127 Crown witnesses, an additional 41 pieces of evidence from witnesses unable to attend, and 6 weeks of closing addresses. The court was closed to the public for parts of the trial. The jury found Eastman not guilty. The inquiry. The inquiry examined the prosecution's case, including most significantly the evidence presented by the forensic expert Robert Barnes from the Victorian Forensic Science Laboratory. Barnes was involved in gathering and analysing the gunshot residue located in Eastman's car, evidence which helped convict him of Winchester's murder. At the original trial, neither Barnes' evidence nor his qualifications were challenged. At the inquiry, however, the forensic evidence collected by Barnes was scrutinised. It was discovered that Barnes did not hold any relevant tertiary qualifications, and that there were serious flaws in his methodology. Barnes' evidence relied heavily on a database of ammunition profiles which had been compiled by a student Barnes had been supervising. Not surprisingly, the ammunition profiles were based on the analysis of only small amounts of material, whereas later evidence showed that the composition of ammunition is highly variable within a single cartridge, within each batch of cartridges, and between different batches. Therefore, it is not possible to identify a particular profile with a particular kind of ammunition, especially based on an analysis of limited quantities of material. Further complications were uncovered, as Barnes had failed to keep accurate records of his forensic work, therefore making it extremely difficult, and indeed almost impossible, to examine the reasoning from which he drew his conclusions. During the inquiry, evidence was given of results that contradicted Barnes' claims that the crime scene residue matched that found in Eastman's car. Moreover, it was questioned whether or not the forensic tests were actually made. Complicating the matter further, Barnes' competence was a concern. It was revealed that he had been subject to disciplinary proceedings in the years before the Eastman trial for misusing state laboratory resources. The inquiry therefore considered that Barnes had behaved in a manner inconsistent with the independence of a forensic expert, and plainly demonstrated his bias in favour of the prosecution. The inquiry's examination of the forensic evidence considerably weakened the initial case, and questioned the evidence which convicted Eastman, as the gunshot residue could have come from other ammunition used in other rifles that Eastman had owned. While Eastman attempted to attack Barnes' forensic evidence, the full federal court had held that the evidence was not genuinely fresh, as it was not evidence which was not available or could not with reasonable diligence have been available at the trial, which is the legal requirement that must be met before new evidence can be called fresh evidence. As merely new evidence, it was not of sufficient strength to justify interference with the verdict. Therefore, from a strictly legalistic point of view, Eastman had not demonstrated any legal errors at the trial, which meant he was unable to satisfy the higher legal threshold of proof attaching to factual errors. Another challenge at the inquiry was the allegation of police misconduct. The inquiry found that during the lengthy investigation period, the police were aware of Eastman's mental state, suffering from a long-term paranoid personality disorder, and had harassed him with the aim of securing a confession. On several occasions, Eastman had told the police he was exercising his right to silence, and that any police contact should be made through his lawyer. This request was denied, and the police continued again and again to pressure him to confess. Police engaged in overt surveillance of Eastman, where they followed him as he travelled to and from his solicitor's office several times a week. However, the surveillance was justified by the seriousness of the case. Two officers, Commander Ninnis and Detective Sergeant Thomas McQuillan, sought to provoke Eastman by claiming to have knowledge of his visits to brothels and his sexual preferences. Ninnis and McQuillan were extremely cunning in their attempts to secure a conviction. Unofficially working undercover, they befriended Eastman and accompanied him to the Australian War Memorial, taking his car keys from him and requesting an interview, trying to provoke him into an angry reaction and saying something incriminating. In the inquiry, it was considered that there were occasions where the police crossed the line and engaged in both unfair and unlawful conduct toward the applicant. While the inquiry accepted that the object of police misconduct and harassment was to obtain a confession, the confessional evidence was still considered admissible in court because the inquiry decided the confessions were made independently of police harassment. Police misconduct was relevant to the trial, as the willingness of the police to breach standards of honesty and integrity began to throw doubt on the credibility of all the police evidence. Eastman's paranoid personality disorder did him no favours during the trial. His mental disorders led him to frequent swearing and breaches of court etiquette in front of the jury. Further, Eastman obtained legal counsel only to dismiss his lawyers and then re-engage them. He was represented by 5 different legal teams in between periods of self-representation. That was one of the bases of Eastman's claim that his disorder rendered him unfit to plead. But his argument was unsuccessful, as the inquiry noted Eastman's intelligence and that he consistently demonstrated an excellent grasp of the issues with which he was confronted. While his argument was unsuccessful, the inquiry found that his mental condition was responsible for decisions that worked strongly to his disadvantage. When he was representing himself in court, Eastman chose to not cross-examine selected witnesses as a protest. One such witness was Dr. Rowantree, who gave the damaging evidence about Eastman's threat to shoot Winchester on the days prior to the murder. That refusal to cross-examine the doctor effectively removed any opportunity to neutralise his evidence. Webb, who claimed he had identified Eastman as the buyer of a gun at Clarenbeek's place at about the time the murder weapon was sold, and a couple of weeks before the murder, had initially told the police that he had not seen anyone at the Clarenbeek property, and gave sworn evidence to that effect at the inquest. When Webb's story changed and he provided the positive identification, he explained that his earlier denial of having seen Eastman was for the safety of his family. In those circumstances, there had to be some doubt that the person visiting Clarenbeek's place bought the murder weapon. The second person who had identified Eastman was the sports store owner Reed, who identified him as the person who attempted to sell him a rifle matching the description of the murder weapon. Reed's identification was on a third attempt from a photo lineup. A photo lineup is a group of photos of people, including the suspect, who all look a little similar. Moreover, the evidence of the gunshot residue and Dr. Rowantree's opinion weakened the evidence linking Eastman to the murder weapon. Due to this, the inquiry determined that although the identifications were circumstantially linked, they did not provide a direct evidential link to the murder weapon. Recognising that the absence of a direct connection between Eastman and the murder weapon weakened the case, the confession evidence assumed a greater importance. Although the confessions were found to be admissible despite police harassment, the inquiry indicated that the confessions lacked sufficient clarity to provide the sole basis for a finding of guilt. Therefore, the inquiry concluded the combination of these flaws demonstrated that the applicant did not receive a fair trial, and recommended that Eastman's conviction be quashed. There was an alternative theory which was given serious consideration in the early days of the investigation into Winchester's murder. The inquiry weighed up evidence that supported the hypothesis that the killing may have been a professional hit by a criminal organisation. Evidence had shown that Winchester had previously been involved in a major drug operation against the powerful Calabrian mafia known as Dragontar, or Honoured Society. He worked undercover to bring down the group's cannabis crop growing near Bungadore in New South Wales. It was believed that the organised crime syndicate had the motive to kill Winchester because he had double-crossed them. That major undercover operation led to the arrest and trial of 11 people, and that trial was underway when Colin Winchester was murdered. The theory that was examined was whether a professional assassination could have taken place for the dual reasons of revenge for Winchester's role in the drug operation and as a warning to potential witnesses not to testify at the drugs trial. Several inquiries were conducted to investigate this possibility, with one viewing it as established on the balance of probabilities. However, further investigations failed to uncover any solid evidence to support the theory, and so that hypothesis was not seriously pursued by Eastman's defence at his trial. In a private, closed session, the inquiry was given another body of fresh evidence in a sealed report. The new evidence was claimed to have potentially lifted suspicion to the level of a reasonable hypothesis consistent with the applicant's innocence. This new evidence gave weight to the view that the conviction could not stand. After 7 days of deliberation, on the 22nd of November 2018, 20 years after he was first convicted, Eastman's conviction was quashed by the full court. On the 1st of October 2019, in a heartbreaking speech, Eastman told the court that he had been robbed of the opportunity to marry, be a father, and have a career. He also said he had been the victim of violent attacks and taunts during his incarceration. Following his wrongful imprisonment, Eastman sought $18 million in compensation from the ACT. The Solicitor General, Peter Garrison, told the court that the ACT government had offered an act of grace payment to Mr. Eastman because it had a moral obligation to compensate him. Eastman rejected the offer made to him and sought compensation under the ACT Human Rights Act, which allowed him an opportunity to seek compensation from a court. However, Garrison argued that Eastman did not meet the legislative requirements to receive compensation under the Act, stating that the Act of Grace offer was the only way to compensate him. In October 2019, the ACT government awarded Eastman $7.2 million in public compensation. Following the acquittal, Mr. Winchester's family was reportedly extremely disappointed. There was little doubt that they were convinced of Eastman's guilt. For them, like all families in that type of situation, there was no closure to the tragedy. On the other hand, Eastman, at 74 years of age, had lost 2 decades of his life. Despite his unlikable characteristics, his resilience to fight for justice is to be admired, as a less resilient person would not have persevered as he did. His time in jail included the trauma of witnessing another prisoner being beaten to death, and himself being moved between jails 90 times in 20 years. As Eastman was acquitted, it is important to remember that the case now remains unsolved, with ongoing speculation about the real culprit. The gun was never located. Former ACT Chief Police Officer Roman Quadvlieg believes that with the acquittal of David Harold Eastman, the 1989 murder of AFP Assistant Commissioner Colin Winchester remains, after all, an unsolved homicide, a high-profile cold case, and should be treated as such. The contrast between the case in the initial proceedings and then in later proceedings is not just unique to this case. Eastman's case emphasises the challenge and questions regarding the effectiveness of criminal procedure. It shows the challenges faced by wrongly convicted people in Australia in convincing criminal justice officials to reassess the correctness of a conviction, particularly post-appeal. Many of these cases demonstrate that there is a serious over-attachment to the prosecution's theory about a case, perhaps arising from tunnel vision or confirmation bias, and the tendency to seize on any evidence which tends to support a particular theory while dismissing anything that doesn't fit. Unfortunately, this can and does continue long after conviction. Since the 14th of October 2019, there have been no open source reports about either David Eastman or how he chose to spend his compensation money. Two questions which commonly arise from wrongful conviction cases are: what reforms can be introduced to reduce incidents or facilitate the identification of wrongful convictions, and why do cases like this take so long to identify? If you have not yet listened to our first episode, we ask that you do so, to discover the importance of Australia introducing a Criminal Cases Review Commission. In the United Kingdom, the Criminal Cases Review Commission provides a good, workable model of what could be Australia's new criminal reform.